Okay, ladies and gentlemen, we're going to come back into session at this point. My paper for this conference is Jewish Legal Rights in the League of Nations, the Palestine Mandate, and the 1939 British White Paper. My co-author and participant on this paper is Ed Rabin. Ed, could you stand up, give a wave here? Ed and I have worked on this paper together. Ed is Professor Emeritus of Law at the University of California, Davis. I teach at Santa Clara University Law School, but I am primarily a practicing lawyer. And so the thing I want to say right now is this is going to be a different kind of paper than you've heard at this conference. You've heard a lot of debates about moral issues in relation to the Holocaust, who had a duty to do what morally. But of course, in the law of nations, nations are sovereign and don't have any legal duties to do any of the stuff we've talked about so far in this conference. In addition to that, you've heard a lot of political history, governments vying against each other in peace and in wartime. And again, these are sovereign nations under the law, and we can't hold them accountable for what they do or don't do. But one of the things that makes a difference here is when sovereign nations sign treaties and enter into engagements and make agreements with other sovereign nations, something special has happened, and that is all of the moral, political, and all of the political considerations have now become legal obligations. And legal obligations are distinguished from moral commitments or political commitments in that, first of all, they are binding and they're continuous. You can't renege. And secondly, there is a mechanism of enforceability. If you violate a legal promise, a legal commitment that you make, you are subject to a lawsuit, potential damages, and other legal consequences. And so we're going to be talking about law for the next hour or so, and those kinds of commitments. Because of that, I am using sources in a very different way than the other speakers have used them. For example, I'm going to cite to economic statistics, I'm going to cite to political history and political events as background to the legal controversy I'm going to be speaking about. But when I get to the British, and the British are going to be the primary focus of what I say, I am quoting them in a slightly different way. If I was involved in a car accident with any one of you, and you went out onto the street after the accident and you said to a bunch of bystanders, gee, I guess I ran the red light and I ran into this guy, Tony. Well, I could call those people to the witness stand, and I could call you to the witness stand and get you to repeat that, what we call admission, and use that against you in the context of my lawsuit against you to recover damages. I'm going to quote the British, and I'm going to quote them a lot, because they made admissions that can be used against them in connection with their legal obligations. So I'm not quoting the British because I love them, and I'm not quoting the British for any other reason except they made admissions about their legal obligations. So, okay, with that background in mind, let's get started. This is a map of the Ottoman Empire as it stood at the beginning of World War I. As some of you may recall from your general history, the Ottomans had an expansive empire. They took the city of Constantinople with cannon in 1453, and that empire continued to move toward Europe, and the gates of Vienna were threatened on multiple occasions. The great story here is the Polish king Jan III Sobieski stood at the gates of Vienna and beat back the Turkish army in 1683 and ended the Turkish expansion. And the Turks plunged into decline for 2 centuries. They picked the wrong side in World War I. They went with what we call the Central Powers and their waning empire. And if you look at the dates on the map, they were losing, had been losing in the 19th century, their entire empire in North Africa. They lost Greece in the 19th century. They lost Crete in the beginning of the 20th century, just before the war. What they had left in this area was Palestine. And so this is an area that they were destined to lose, having picked the wrong side in World War I. Now, what happened to them in World War I? This is a battle plan map. This shows the advance of General Sir Edmund Allenby, a British general from Egypt, fought a great battle at Beersheba, but that's not on this map, occupied Jerusalem, and then ultimately went to Damascus. And I think some of you who know the war know what's going on the right flank there. That's the Arab army under the leadership of Lawrence of Arabia. And if you've seen the great movie with Peter O'Toole, that depicts the support the Arab army was giving to General Edmund Allenby. But the bottom line is, at the end of World War I, Edmund Allenby had his troops all over Palestine. He was in military control of Palestine. At the end of World War I, there was a problem. The Turkish Empire had disintegrated. There were a number of territories, Syria, Lebanon, Iraq, Palestine, that were now not part of Turkey anymore, occupied to some extent by the British, but also by Arab tribes and other national interests. The British and the French talked a good deal about what to do about this problem post-war. They were the victorious allies. And the League of Nations was in the process of formation. Our President Woodrow Wilson, who was a great idealist about nations getting along with one another, was putting together a League of Nations. All these things were going on at the end of World War I. In the meantime, in addition to these territories becoming under the control of the Allied powers, something else was going on. We are going to, in this presentation, compare one facet of British rule, and that is the Palestine Mandate, which was a treaty between post-World War I League of Nations and the British. And we're going to make a comparison here. The post-World War I mandatory system of the League of Nations, under which Britain was ruling Palestine, and with the global Zionist movement. What I'm going to show you is what impact the global Zionist movement had on Britain and the mandatory system in Palestine. First of all, what's the mandatory system? The purpose of the mandatory system was to guide and govern former colonies of Turkey in accordance with the League of Nations Covenant, Article 22. And I'm a lawyer, and I'm going to quote the language of some of this stuff. Bear with me on that. I hope I won't bore you too much, but words are important in the law because they're really all we have at the end of the day, and they're what we have to enforce. So Article 22 applies to any former colony or territory that is no longer under colonial or imperial power. That would apply to the Mideast, and is inhabited by peoples not yet able to stand by themselves under the strenuous conditions of the modern world. It was the judgment of the Allied powers and the League of Nations that Palestine fell in this category. That is, it was a nation that could not yet stand on its own or govern itself. So what's going to happen to these former colonies? Normally, before World War I, the process was simply that the winners would gain the spoils. Whoever won, whoever occupied, whoever militarily achieved the victory would wind up with a colony in the form of that former territory. Not so anymore, says Woodrow Wilson and a lot of other idealists who formed the League of Nations. They said, no, we can't have this system. This system is denying indigenous peoples their right to their own destiny. So this is what's proposed by Article 22. A former colony or territory is, first of all, a sacred trust, says the League of Nations. The well-being and development of the peoples of this kind of region or territory are a sacred trust for civilization. So, instead of the victor gaining the spoils, those territories are going to be administered by a league-appointed and supervised mandatory. They will be placed under the tutelage, says the League, of a foreign nation acting as a mandatory trustee, and they'll do so under the terms of a legal instrument or treaty that is called a mandate. So we are going to create for each of these territories a mandate and name a mandatory to rule that territory, to protect and guide and tutor the peoples of that territory as they move toward statehood and controlling their own destiny. Now, the Zionist program. We're going to jump to that just as a matter of background. The Zionist Congress of 1987, led by Theodor Herzl, was inspired largely by Tsarist pogroms and the persecution of Jews, especially in Russia and Eastern Europe. At this initial conference, and this is, of course, 1897 is before World War I, before the end of World War I, certainly, Zionism aims at establishing for the Jewish people a publicly and legally assured home in Palestine through various means, including, number one, the promotion of the settlement of Jewish agriculturalists, artisans, and tradesmen in Palestine. So, we're going to have a publicly and legally recognized home, and we're going to achieve that home through, I'm sorry if this is a dirty word in some quarters today, settlement of all these kinds of people. This is something that's familiar, I think, to most of you. And I'm skipping just a few years down the road. There's lots of other history here. But we have something called the Balfour Declaration. The Zionist movement was pushing for this, advocating for this among the Allied powers in World War I for this entire period of about 20 years. And they finally achieved it. This is Arthur Lord Balfour, and this is what he wrote. Notice, in particular, this is a commitment to Zionist aspirations, says Lord Balfour. He says, I am committing my nation, Britain, through the Cabinet of Britain, my government, to Zionist aspirations. And he writes this letter as a result of that, and he says, His Majesty's government will use their best endeavors to facilitate the achievement of the object of the Balfour Declaration, which is the establishment in Palestine of a national home for the Jewish people. There is a proviso there that we will not prejudice the civil and religious rights of non-Jewish communities when we do this, and we will retain the rights and political status of Jews in other countries. In other words, a Jew then can be a citizen of any country the Jew wants to be a citizen of that will allow that Jew to be a citizen, but the Jew will also have a new national home in Palestine in addition to that, the proviso being that you will not interfere with the rights, religious and civil rights of the people in the Palestine area or territory. That's the commitment of the Balfour Declaration. And notice that Balfour specifically asks that this be communicated to the Zionist Federation. So clear references to Zionist aspirations, Zionist goals, and the Zionist organization. Okay, some notes on this. As I said, this declaration, it was not simply Britain's declaration. It was put out at the time publicly, and it was endorsed by all of the Allied powers. Everybody made a public statement saying, this is what we want, a Jewish home in Palestine. So it had wide support. It made a very positive impression on Jews worldwide. They were thrilled that the Allied powers, the winning powers in World War I, were actually committing themselves to providing something for Jews worldwide. On its face, it supports Zionist aspirations and, as I said, a national home for the Zionist people. So, okay, that occurs in 1917. Now we go, the next major event, to the Paris Peace Conference of 1919, right after World War I. That conference shaped the mandate that we're going to talk today. Britain had conquered Palestine. The Zionists sought to use the proposed Palestine mandate to achieve the Jewish national home. All of the Allied powers were behind this, and the Zionist proposals at the 1919 Peace Conference were incorporated virtually verbatim. I'll give you some examples of where it wasn't verbatim, but they were virtually copied into the mandate for Palestine under which Britain was to rule Palestine. The Palestine Mandate of 1922. The League Council issued this mandate. So the Council of the League of Nations, about 50 members, 50 nations at that time. The League Council, on behalf of the League, issues this treaty or mandate to Britain, which accepted it. Article 1 grants Britain legislative and administrative powers as the mandatory of Palestine, subject to the terms of the mandate. Mandate's got about 25, 27 articles. Article 2 requires Britain to create conditions to achieve the Jewish national home, to safeguard civil and religious rights of all people in Palestine, and finally to promote self-government. And Article 6, which is the article we're going to talk chiefly about today, requires Britain to facilitate Jewish immigration and to encourage, here's the dirty word again, Jewish settlement in Palestine. Ongoing commitment to do that. So that's a sketch of the mandate. At the same time, guess who arrives on the scene? Sir Winston Churchill. At this time, not yet a sir, but he was a major part of the government. He was the colonial secretary, and the mandate was classified as a colonial obligation, so it came under his purview. And Churchill said immediately, we have to have a white paper, which is a statement of British policy as to how we're going to interpret these obligations that we have under the mandate in relation to the rights of all the people that are in Palestine. And so this is our interpretation of what we're going to do in ruling Palestine. He says, first of all, the mandate does not guarantee a Jewish state. And he made that statement emphatically. He said, it doesn't guarantee a Jewish state. The mandate doesn't speak to politics, doesn't speak to the future state that might exist in Palestine or who might run it. But what it does provide is a guarantee for the further development of the existing Jewish community in Palestine, which was about 10% of the population at that time, with the assistance of Jews in other parts of the world. So this is a commitment to Jews worldwide, not just the ones in Palestine at the time, but to Jews throughout the world. The Jewish national home will be created, facilitated, and supported by the British. It also said this Jewish national home will be internationally guaranteed. So Jews worldwide, this is not simply Britain's word, this is an international guarantee of what you will have. And it will be guaranteed by legal right and not on sufferance. Not just because we're going to tolerate you, you will have rights under this commitment. And those rights will be based on your ancient historic connection with the land of Palestine. Jewish immigration is assured under Churchill's doctrine in the White Paper of 1922 to the economic capacity of the country at the time to absorb new arrivals. So in other words, immigration continues as long as it doesn't impose an economic burden or create job losses. If people are going to lose their jobs massively, they're going to be out of work, they're going to have to be supported, there's going to be economic deprivation, then immigration levels can be controlled. But beyond those purely economic circumstances, there is to be immigration of Jews, specifically to Palestine. All right, now, so what happened in implementing this policy after Churchill declared it? Jewish immigration and capital investment were allowed and encouraged in Palestine. And this means, ladies and gentlemen, and I'll say it frankly, it means Jewish money, primarily from the United States, but also from nations all over the world. And what was the result of that? Jews grew from 10% to 29% of the population in 1939. The Arab population increased as well, in numerical terms more than the Jewish population did in that same period. So the Arabs benefited from all this activity that was going on in terms of an increase in their population. And they were roughly 70%, 65-70% of the population in 1939. The British legal position, and the British expressed this legal position to the League of Nations, was we are going to interpret the mandate as allowing equal treatment of all races and ethnic groups regarding immigration. So everyone has a right to immigrate up to the economic capacity of the country. So we're going to treat Arabs that way. We're going to treat any other group that wants to come into the country in accordance with that economic criteria. However, the British financial position was Palestine is to be treated the way they would treat a colony economically. It's got to pay for itself. We are not going to pay for this endeavor. It's got to break even. It's got to bring in some money. Well, where's that money going to come from? It's going to come from taxation of a government there. And to have taxation, ladies and gentlemen, you have to have a successful endeavor, which means capital, which means Jewish capital through settlement and through immigration. That's what's going to develop Palestine. The Arabs resist any Jewish immigration or any sales of Arab property to Jews from the outset. Britain responds to the Arab protests and objections by saying that it will not relinquish the mandate, it wasn't going to quit, and there was pressure within Britain to quit. Just back out of this. You're never going to be able to deal with both Arabs and Jews, so quit, back out. And the response was, no, we are not leaving, and we must and will support the Jewish national home with immigration, notwithstanding the Arab view. Internal security was generally maintained in Palestine until about 1936, when the Arabs revolted, and the British all of a sudden had to spend £2 million in 1937, 1938, at 10 times what they usually spent for security, which was £200,000 a year. To suppress that revolt was terribly, terribly expensive. And that expense was something that was significant. Churchill himself had said, we shouldn't even do the mandate. We shouldn't start it. But nonetheless, Britain stayed the course. Britain made the commitments. And you can read from tons of Palestinian scholars who are livid with Britain for maintaining the mandate and moving Jews into Palestine. And they document thoroughly what's happening in this era. Britain is being pressured to abandon this commitment, and they're saying, no, we are committed to Jewish immigration and Jewish settlement in Palestine. So, what happens next? Britain obtains the League's permission in 1937. Now, this is in light of their £2 million expenditure. They're saying at this point, boy, this may not be worth it. So maybe to quiet down the Arabs here, let's partition. Let's just divide up the property, have two nations, and we'll step back, we'll control Jerusalem for the benefit of all faiths, and we'll get on with things in that way. We'll still have a foothold there militarily, but we won't have all these fights because everybody will have his or her own nation. They go to the League for this, which means they go through the League's mechanism. There was a permanent mandates commission that they had to report to annually that reviewed their work, that went through the whole matter and went to the League and said, please give us permission to partition the country, which would mean the end of the mandate with respect to that partition. So, problem. The League gave its permission, says, sure, fine, go right ahead. We can partition the country. And a British study commission then studied how to do this in 1938, the Woodhead Commission. And the Woodhead Commission concluded that any Arab state would not be financially self-sufficient. The Jews were paying 60% of the taxes, and we can't draw lines to have a Jewish territory and an Arab territory and have a self-sustaining Arab territory. And the commission recommended that Britain provide some financial subsidies to get this going, because it was the best solution, the solution they themselves had proposed. And guess what? Britain says no. Want to break even here? We're not going to subsidize this. Even that £2 million was taken eventually out of Palestine's budget. People in Palestine paid for that. So we're going to resist this. And so what's next? Where do we go from here? We've got a mandate which we think is unworkable, say the British, and but it's too expensive to try to partition, so what are we going to do? We've run this for 17 years in the same way, allowing immigration. The Arabs hate the immigration, they object to it. So, what are we going to do? And what had changed? After the 17 years of allowing immigration and settlement, we were now, more than 6 months after Munich, on the verge of a new world war. And Britain had a strategic interest, military interest, in a quiet and inexpensive Palestine during the wartime. Not wanting to relinquish the mandate as unworkable, because if they relinquished it, walked away from it, at that point, they wouldn't be in Palestine. Why is Palestine important? It's important because of the Suez Canal, and it's important because of the prospect that perhaps the whole Middle East would become a base of operations for the Nazis, the other side. So Britain got the Arabs and Jews together at the St. James Conference, and you've heard references to that from a number of the speakers, and warned them that it would impose new immigration and settlement policies if they did not agree. They did not agree, and now we have the 1939 White Paper. Britain suddenly abandons 17 years of immigration and settlement under the Churchill Doctrine, and it imposes static population and political power controls. The Jews would be limited to no more than 1/3 of the population. The Arabs would have 2/3 of the population. In addition, Jewish immigration was limited to 15,000 a year for 5 years. That's 10,000 regular plus 5,000 refugees. And after 5 years, no more Jews could enter Palestine without Arab consent. Now, given 20 years of Arab opposition, this meant that Britain knew no such consent would ever be given, and that would end Jewish immigration. As a part of this change, Arab immigration remained unlimited. Last part, the Arab land sale restriction. Arab land sales to non-Arabs were restricted under the 1939 White Paper or banned altogether in the vast part of Palestine. Sales of Jewish land, on the other hand, remained unrestricted. So, now we have this White Paper. It is a 180-degree turn from Britain's policy for 17 years. What's the legal recourse? This appears to be, on its face, a violation of legal obligations. Where do we go? Do we bring a lawsuit? Do we go to the league? What do we do? Well, there were 3 avenues. There was a Permanent Mandates Commission, which reviewed what Britain did annually, but it was purely advisory. It advised the League Council, and the Council could review Britain's performance, could change the mandate if it needed to be changed, and could presumably terminate it or condition British authority. However, the Council acted by unanimous vote, so it would have to be unanimous to any decision to do that. There was also a Permanent Court of International Justice which could hear disputes between Britain and any other League of Nations member who could assert the interests of their own peoples if they wanted to, but there was a court where somebody could sue and one could obtain a judgment awarding money damages as well as judicial declarations of rights. Judgment was determined by a majority. So, 4 questions. Did the Permanent Mandates Commission's review of the White Paper cast any light on whether what Britain had done here was legal or illegal? Did the British White Paper transgress the mandate? Was Britain legally responsible for any injuries resulting from or arising from its violation? And finally, what were the rights and responsibilities of the United States, if any, in relation to the White Paper? Those are the things I want to talk about. So, there's the Permanent Mandates Commission. This is the group here. I would take the time to identify everybody, but these are all people that have experience in colonial administration. There are 7 of them on this commission, and they were the first line of legal attack and evaluation of Britain's position. So what did they decide after they reviewed Britain's 1939 White Paper? First, this group of 7 representatives unanimously determined that what Britain had done is it had changed the entire way it was governing Palestine. So this was a complete change. Everyone agreed, including a British member and a French member, who were both from states that held mandates and had every reason to say this was not the case. They both said, no, we agree this is a 180-degree shift from everything you've been doing to clamp immigration and clamp land settlement. Second, by a vote of 4-3, it's a little bit closer this time, the Permanent Mandates Commission declared that this was a violation of the mandate. The minority of 3 said that even though this is a departure from everything Britain's been doing, the existing circumstances would justify the policy of the white paper. And again, in a Weasley way, they said, provided the council agreed that this 180-degree turn was really justified. So these 3 people were not being terribly forthright in what they were saying, but they were just suggesting that, yeah, this major revolt of the Arabs, and did I mention the 2 million pounds? Those things might justify some change here. So in the normal course, what would have happened? The League Council would have reviewed the recommendations of the Commission, what I just laid out, and it could make orders, make changes in the mandate, cancel the mandate, do all kinds of things. It normally would have done this. The other thing that normally would have happened is someone could have sued in the international court. Any nation could have said, look, this is a violation of the rights of Jews worldwide, and we want the court to declare that Britain's white paper is illegal, and we wanted to award money damages if there are any, and if we can prove any, from the violation. That normally would have happened. But neither of those things happened. Why? The League collapses at the end of 1939, just as the Permanent Mandates Commission is finishing its review of the white paper. So the council never again met, except to disband. The court never heard any substantive dispute after that date, wasn't available for a lawsuit. League nations and institutions and structures collapsed, and ultimately, after the war, got folded into the United Nations, but they were ineffective during the whole time of the war. There was no League international government or law enforcement during the Second World War. So, the Great League of Nations, which was envisioned as something that would muzzle the dog of war, had been a complete failure. The world was now going into its second war, and the League had had little impact on that. Publicity regarding the League at the time was not favorable at all, as you can imagine. Here we have international law and order represented by the League in the form of the 3 monkeys who see no Abyssinia, hear no Abyssinia, and speak no Abyssinia, Abyssinia being Italy's invasion of Ethiopia or Abyssinia without any intervention by the League. This was disgusting to the majority. The throne of justice was the 3 monkeys who heard nothing. And the League of Nations fell asleep in Abyssinia after prolonged non-implementation of policy on sanctions. Here is the weeping for the League. This is from Punch magazine at the time. So this is Mussolini's assessment of the League. Mussolini, the victor in Ethiopia. Mussolini says, the League is very well when sparrows shout, but no good at all when eagles fall out. When major nations are going to come into controversy, what's a League of Nations worth? So says Mussolini. And that's, I think, the ultimate verdict. So, okay, the League institutions are gone. So from now, at this point, we're going to enter a legal historical exercise, and we're going to ask ourselves the question, if there had been some institution to which Jews of the world, to which nations purporting to represent Jews of the world could have gone, what would have happened? What did the mandate have to say about what Britain did in the 1939 White Paper? The mandate is an international treaty. As I've indicated, its parties are Britain and the League of Nations. A treaty has to be read as a whole. You read all 26 or 27 of these articles of the treaty together and all their parts in order to determine what it means. And language does have meaning. Words are interpreted according to their plain meaning in the mandate. In context, they are construed to accomplish the purpose of the treaty or the purposes of the treaty. And finally, in interpreting a treaty, like a contract or any other agreement, actions speak louder than words. A treaty interpretation that is actually adopted by the parties themselves as a matter of consistent practice is favored over any other interpretation. So, again, we're going to ask ourselves now, what do the words say? And then, are there any actions? And maybe I've given you a clue to what they might be as we go through. There are several considerations. First of all, words and phrases in Article 6 describing Jewish immigration. There are limitations in Article 6 and elsewhere addressing the rights of non-Jewish groups. There's also a historical and linguistic context of the mandate. And then finally, there's the on-the-ground actions and conduct of Britain as the mandatory, in conjunction with the League and in conjunction with the global Jewish community. Article 2, I quoted this before, Britain is supposed to do three things. They're supposed to establish the Jewish national home as laid down in the preamble. They're supposed to develop self-governing institutions in Palestine, and they're supposed to safeguard everyone's civil and religious rights. So, what is the Jewish national home? What do those words really mean? We take it word by word, and I've taken this all from the Oxford English Dictionary of 1933 because the law tells me I need to interpret these words in the context of the time. So, Jewish, a member of a people and a cultural community whose traditional religion is Judaism and who trace their origins through the ancient Hebrew people. Notice the ambiguity of the word Jew or Jewish. Is this a cultural or ethnic word, or is it a religious word? Well, the answer is it's both, and it's a combination of both. So right away, you have a difficulty in determining who is or who is not a Jew, and that comes into context here. Second, very thorny issue here. Now, go to association, national. An association with a political state within a defined territory. A Jewish home in Palestine is something that has to belong to the Jewish people in some significant way as their national home. And it has to be national. So as a nation, the Jews have to have some relationship to the home. And then, finally, home. I love the word home. This was a word, a Zionist word, by the way, picked out by a Zionist. The term Jewish national home was coined by Zionists and got into the mandate through Zionist proposals. Home is a place where one resides as a permanent resident, an institution providing refuge or rest for the destitute or for those who have no home of their own. Extremely articulate. And Churchill, the most articulate man in Britain of his generation, this is what he said about the home. It is a pledge for a home of refuge or an asylum to Jews worldwide. To the vast unhappy mass of scattered, persecuted, wandering Jews seeking a national home in Palestine. Could it be more eloquently put than that? Clear, straightforward, eloquent. The preamble. The preamble says the Jews had a historical connection through their people with Palestine and to the grounds for reconstituting their home in that country. Those grounds were very cleverly not described in the mandate because they came directly from Zionism. The Zionist peace proposals of 1919 included a Jewish connection, but not a claim. And this is the one thing the Jews didn't get in 1919. They didn't get a state, they didn't get a commonwealth, they didn't get a claim to land in Palestine. No one was going to declare in 1919 that the Jews all owned all the land in Palestine. No one was going to declare that they had a right to go there and found their own state. Those things were not subject to discussion. Instead, Palestine's development was going to be promoted. It was a desolate area, said the Zionist proposals, that needed a population that was energetic, intelligent, devoted to the country, and backed by the large financial resources that are indispensable for development. Zionism historically emphasizes the close agricultural settlement and development in Palestine, and that's exactly what the mandate buys into. The pro-development rationale is apparent in 4 articles of the mandate. Article 4 declares that the Jewish agency is a public body. That means a body created by and connected with the government in Palestine. And what's that body going to do? It's going to cooperate with and advise Britain in connection with the Jewish national home and Jewish interests, and it's going to secure the cooperation of all Jews in the world. Why do we want that? Because we need Jewish money to do this. So we're going to have a link to the Jewish community to get Jews to pour in the millions that are going to be necessary, of dollars, that are going to be necessary to develop. Article 6. I read that before, I'll go over it again later. Jewish immigration and settlement were guaranteed. Palestinian citizenship was guaranteed to any Jews that became permanent residents. And finally, in Article 11, the whole community interest in development was to be safeguarded, development was to be promoted. The Jewish agency was to carry out public works at reasonable profit. And a land system was to be established promoting close settlement and intensive cultivation of the land. Pro-development, active, dynamic. Encouraged immigration up to economic capacity, and the only prospect of this was Jewish immigration with capital, so we're going to have dynamic development. 80% of the Jewish capital, by the way, to develop Palestine came from individual Jews that decided they wanted to live in Palestine, do business in Palestine, settle, engage in agricultural activity, and so they moved with their money from places where they could do that, like the United States. Only 20% came from Jewish organizations. So the development project succeeded in the 17 years through 1939. Arabs consistently resisted all of this, but the British stayed the course, and there were challenges to this both in 1920, 1925, and 1929, 1931. The Arabs were pushing against this. The Brits were moving right along with it. When the whole world was in the depression of the 1930s, Jewish capital was flowing and developing Palestine. Palestine was economically up in the 1930s, just contrary to the entire rest of the world. So now, let's look at Article 6. The administration of Palestine, while ensuring that the rights and position of other sections of the population are not prejudiced, shall facilitate Jewish immigration under suitable conditions and encourage in cooperation with the Jewish agency referred to in Article 4, that is this public Jewish agency, close settlement by Jews on the land. Those are the 2 things that are commanded. The only exceptions there is that you not prejudice the rights and position of other sections of the population. So that's the question. What are Arab civil rights and position? The arguments for the 1939 paper made by Britain were 4. First of all, that Arabs had civil rights, and they had a right, according to the British, to maintain a 2-to-1 ratio in population and control Palestine. Second, the intent of the Balfour Declaration, says Britain, was to protect Arabs and to limit Jewish influx in immigration and land purchase. Third, we already have 400,000 Jews now in Palestine, so we don't need a Jewish national home anymore, we've got one. And finally, political factors. The Arabs are being violent, we need to appease the Arabs. So this is a 4th argument. These are their 4 arguments. Let's look at the 4 arguments. The elephant in the room, the 5th argument, is what? Military and strategic necessity at the beginning of a new world war. They never mentioned that. They never used that in their arguments to the Permanent Mandates Commission. But the commissioners, one of the commissioners, these people, they speak in very mild, indirect ways in the 1920s. But one of the representatives from Norway, an absolutely brilliant woman, school teacher, that had the only woman's seat. There was a woman's seat on the Permanent Mandates Commission. And she said to the British, I think there are broader strategic considerations at issue here than you are allowing. And that was as strong as it got. So let's take a look at the so-called civil rights argument. I love this argument. Article 2 requires the protection of civil rights of all inhabitants, regardless of race or religion, and Article 6 requires no prejudice to the rights and position of other sections of the population, including Arabs. Therefore, says Britain, Jewish and Arab rights have got to be balanced. And well, we've let the Jews get up to 400,000, we've given them all kinds of things. Now it's time for us to go the Arab way for a while. We've got to balance this out. I mean, we're in the position, right, we have to protect everybody. Britain says the Arab position includes a political civil right to control a future government and to block immigration and land purchase. That's essentially what they said. Arabs can stop it all, and Arabs can also control whatever the government is with at least a 2/3 majority. Well, problem number one, there are no political rights granted by the mandate. They're not there. There's nothing in the mandate that says 2/3, 1/3, or any other set of political rights is granted to Arabs, to Jews, or to anybody else. What the mandate does say is that there is to be no racial, religious, or other group guaranteed political control. Political control is dynamic. Whoever comes out ahead, whoever gets the majority, however a government might be formed, that's something we're not going to deal with. We're simply going to develop the country, and we're going to let the chips fall where they may. Whether that's naive, whether that's unreasonable, we can debate that. And certainly if we had Palestinians, they'd be on their feet right now screaming and shouting me down. But the reality is that's what's in the mandate. That's the model that's built into the mandate. There was a San Remo conference when the mandate was being drafted where France proposed adding political rights to the language of the mandate. The British adamantly refused, and that was shot down. So civil rights do not mean political rights. The only understanding that Britain said was we will not deprive people of their right to vote or to take part in elections that they had at the time of the Turkish Empire. Well, Britain never did that. People continued to vote. They had local elections. There was no problem with that. No political rights or positions were guaranteed in any of the mandate. So, problem number two, Britain defeats the Jewish national home. The presumed Arab majority always disapproved immigration and settlement. However, the mandate expressly required conditions establishing Jewish immigration and settlement. A guarantee of Arab political supremacy would defeat both Article 2 and Article 6. And remember what I said, all the words of the mandate, all the obligations of the mandate, all the rights of the mandate must be read together. You can't erase two provisions of the mandate and step back and say, what I've done is consistent with the mandate. If what you're doing destroys parts of the mandate, you have violated or breached the mandate. Problem number three, the League Council itself had approved settlement and immigration under the British Churchill Doctrine. There was a dispute in 1930. There was a question about whether or not the Churchill Doctrine of immigration based on the absorptive capacity, the economic capacity of the country, was to be fulfilled. Britain agreed, and the League ordered immigration and settlement restrictions are to be temporary only, and settlement is to continue under the economic ability of the nation to absorb new residents. That's it. It became established practice and legal law in 1930, and the resolutions are available, and I cite them in the paper. What's the alternative then? I mean, do Arabs have no rights? Are we trampling on the rights of the Arabs? Are we destroying the Arabs in this nation? An alternative position is simply the Jewish immigration and settlement cannot be accomplished by displacement of the inhabitants of Palestine from their jobs, nor can they be achieved by forced sales or confiscation of inhabited lands, something that never happened in Palestine. No one went into Palestine and kicked an Arab out from an Arab's job. No one went into Palestine and stole land, occupied land, conquered land. Those things did not happen. That interpretation gives meaning to the rights and position of all groups in society to be where they are, in other words, to have the rights to purchase and hold land, and to have the rights to a job and to participate economically in the country, and those things continue to be guaranteed. Under the Churchill Doctrine, immigration is available to all groups, and there is a free market in land. These things all respect the rights and position of everyone in the society. If you deprive them of those rights, then there conceivably could be a violation. But that's not what the white paper does, and that's not what was proposed. Under Article 6, there also have to be suitable conditions for immigration, but these also are dictated by the Churchill Doctrine. All groups can enter up to economic capacity. That was the process for 17 years, and the League had ordered in 1930 that this is the rule of the mandate. This alternative interpretation, unlike the white paper, accords with the mandate, history's language, the history, the established practice, and the legal counsel guarantees. All of these devices to interpret the mandate are met by the interpretation I've just given you, and they're all violated or opposed by the 1939 white paper. Problem number 4. Here is a wonderful provision of the mandate that guarantees equal rights. There shall be no discrimination of any kind between the inhabitants of Palestine on the ground of race, religion, or language. No person shall be excluded from Palestine on the sole ground of his religious belief. A ban on Arab land transactions infringes both the rights of Arabs and the rights of non-Arabs to enjoy their rights to buy, sell, or mortgage land. So this kind of deprivation is a discrimination based on race. Arab land can't be bought, Arab land can't be sold, Arabs can't take advantage of their land by borrowing money or selling the land. Jews can't buy the land. So the rights of both of those groups are infringed based on racial grounds. Violation of Article 15. The Balfour Declaration argument. This argument is absolutely ridiculous. It was based on promises made to the Arabs in something called the McMahon-Hussein Correspondence, shortly after the Balfour Declaration. You know, when the Balfour Declaration was issued, the Arabs got excited. They read it, they didn't like it. And there was a sheikh called Hussein that had been part of the Arab revolt in the desert and ridden along with Lawrence of Arabia and done all the rest of these things. And he said, oh, you know, what is this? What is this? You're going to take all our land? You're going to... Well, some British civil servant called McMahon, wrote him a letter and said, no, we're not going to do any of that. Britain will support Arab rule eventually in the lands in the Middle East. Don't worry about this, no problem. And the British dragged this letter out of the archives and slapped it on the table before the Permanent Mandates Commission and says, no, that's what we intended. We wrote it right after the Balfour Declaration, and we told him the Balfour Declaration wouldn't affect us. Now, why is that silly? I hope everybody sees why that's so silly. You know, someone makes a contract and then communicates with one other party about it, doesn't tell the other party, and then we're going to use that to interpret the meaning of the contract and what it meant and what the parties thought it meant. The parties to this contract are Britain and the League of Nations. The Arabs just don't have anything to do with it. Hussein doesn't have anything to do with it. A private communication with Hussein that is what we call in the law undisclosed unilateral intent is irrelevant. The intent of the Balfour Declaration, the words of the Balfour Declaration are incorporated in the mandate. And whatever evidence is used has got to be shared by Britain, the Allies, and the League of Nations, and this letter had nothing to do with that. It was Britain's private way to sell the farm twice. You know, sell it to the Jews, tell them they're going to be protected, sell it to the Arabs. So, okay. Finally, the other argument. Jewish national home has been established by, basically by 400,000 Jews. We've gone from 10% to almost a third of the population. But nothing in the mandate declares that the Jewish national home is established based on a population figure. Nothing suggests that. And it's contrary to the council order I mentioned and the 17-year practice, which says immigration is continuous, immigration can't be cut off except on a temporary basis, and immigration has to be based on economic capacity. And if this is the case, if the Jewish national home has been established, then guess what? Is this a home? Is this a refuge? We're now facing Hitler's persecution of Jews in Europe. Do those Jews have a national home in Palestine if they can't get there? And they aren't allowed to live there? And they aren't allowed to reside there? That's not consistent with what a home is, specifically as articulated by Sir Winston Churchill. Article 6 immigration provisions are dynamic and continuous. There's no limit here except suitable economic conditions, and Britain is not empowered to cut them off permanently. Finally, the political factor of Arab discontent doesn't merit much attention. Britain had successfully put down Arab revolts before, and the only difference was 1936 was more expensive, a lot more expensive. And Britain, however, had refused then to support partition. They didn't want to get out of being a mandatory, but they just wanted the opportunity to completely reinterpret the mandate, as they had done for 17 previous years. Well, what do we say about this? British expression, in for a penny, in for a pound. What it means is, if you make a commitment and you think it's going to cost you a penny, but it costs you a pound, you are committed. If you're in for the penny, you're in for the pound. Well, Britain liked the penny, didn't like the pound. The white paper was supposedly politically astute, but an ounce of prudence is worth a pound of cleverness. Britain was not prudent in what it did in 1939. It was clever, and cleverness wasn't going to do it. Now, the question then becomes, we've got a violation of the white paper. Is there anything that can be done about the violation? Well, it looks here in 1940 to 1944 that Britain had at least 22,000 places that even under the white paper were not filled in its immigration quotas. So 22,000 Jews could have come to Palestine under Britain's own white paper 1939 quotas, which I'm saying violated the mandate. If the mandate had been conformed to, it would have been closer to 100,000, because by 1936, a unanimous Anglo-American commission found that 100,000 immigrants could be admitted immediately to Palestine, immediately. So there was a lot of capacity here. And Britain's violation deprived anywhere from 22,000 to 100,000 Jews of places that they deserved in Palestine. So Britain could have been sued here for what we call money damages, for personal injuries, wrongful death, and economic loss. And the League nations, I should say, nations like Romania or Bulgaria or other nations could have made claims for injuries or deaths of their own nationals, according to international law. Did these deaths or injuries occur? You all know the stories. We've got here Jews detained and imprisoned by Britain, coming from the ship Patria, sent to Mauritius, which is an awful place. Most of them got malaria there. And wives were separated from husbands. They were in prison conditions. Damages can be recovered for that because it's a violation of the rights of those people. They had a right to live in Palestine, and a lawsuit should have been brought. Second, Jews refused admission to Palestine or deported to death camps. 8 ships that we know of, including the Salvador, were intercepted by Britain trying to get to Palestine, turned around and sent back to Romania, to Bulgaria, to Poland, to other countries, and the Jewish Agency has traced what happened to some of these people and what happened to them. Some went to the death camp at Majdanek. A bunch of children were sent to that camp who were trying to get in Palestine. Their parents had parted from them and said, let them get to Palestine. They went to Majdanek. Same thing true of other camps. A whole bunch of the Jews in Romania went to Auschwitz. These Jews died as a result of the violations of the mandate. And countries of the world like Bulgaria, Romania, other countries that had these nationals as citizens can sue and could recover for those damages. Finally, the Struma. I won't go through the details of the Struma because I don't have time, but Jews were killed here en route to Palestine. Alex described it in his presentation, talked about this ship, which Britain said, we won't take these people, about 800 of them. 200 of them were children. The other 600 were doctors and lawyers and professionals from Romania. And Turkey said, well, okay, we can't take them. And so their very limited ship, I mean, this ship couldn't tug, and cover the length of this building. The ship was abandoned out in the middle of the Black Sea, was probably sunk by a Soviet submarine. Loss of everybody on board except one person. So, what is this? This is all legal history, right? For all the sad words of tongue and pen, these are the saddest it might have been. It's too bad there was no court, there was no League of Nations Council, there was nobody to hear the Jews. But wait, there's more. Article 37 of the Statute of the International Court of Justice of the United Nations, 1948, says that treaty disputes that are subject to the League of Nations go now to the International Court of Justice, and some of you have heard about that because it made a horrible decision in a case called The Wall. But that court's available and that court's open. Well, now, in the kind of law practice that I do in California, normally that wouldn't make a heck of a lot of difference because we have something called the statute of limitations. And we're long after these illegal acts of Britain occurred. But there is no statute of limitations in international law. The International Court of Justice remains available today to hear cases against Britain for its egregious violation of this mandate. There was a case in Southwest Africa in which the court said it cannot be admitted that the obligation to submit to supervision has disappeared merely because the supervisory organ, for example, the permanent court or the council, has ceased to exist. There is still a court available, and it is a court now of the United Nations. And so an investigation could be undertaken, and believe it or not, a Romanian lawyer undertook such an investigation and later became president of Romania, and so he dropped the investigation and no lawsuit was ever brought. So here we have it. Is any lawyer going to pick it up? It's there. Now, what do Churchill and Roosevelt have to do with this? Here's Churchill in 1939. At the time the White Paper was issued, Churchill was what we call a member of Parliament at that time, did not have a specific government office. And what were Churchill's views? When the White Paper came before the House of Commons in 1939, in the month of May, Churchill made a magnificently eloquent speech against it. He called it a breach and repudiation of the Palestine Mandate. He voted against it. And then, when he was in the cabinet, he voted against the regulations of land that were made in Palestine pursuant to enforce the mandate. When he became prime minister in 1940, what did he do? He maintained this mandate throughout the war. Said nothing. Fell into silence. All of his eloquence in the House of Commons and all of his articulated beliefs that this was a repudiation and abandonment of what he himself had created as his interpretation in 1922. It meant nothing to him during the war. He was unwilling to stand up to ministers that he could fire. Now, let's go to Roosevelt. Roosevelt is clean so far, right? This doesn't have anything to do with the United States. This is a British commitment. And so we should give Roosevelt a pass. Roosevelt, of course, is the great hero of everybody. What were Roosevelt's views about the White Paper? Roosevelt wrote a memo to his Secretary of State, Cordell Hull, in which he said, well, the mandate undoubtedly did not intend to take away the right of citizenship and of taking part in the government on the part of the Arab population. It nevertheless did intend to convert Palestine into a Jewish home, which might very possibly become predominantly Jewish within a comparative short time. Certainly that was the impression that was given to the whole world at the time of the mandate. This is exactly what I have been saying in this presentation, succinctly summarized by Roosevelt himself. This is a dynamic model. Immigration continues, development continues. The politics fall where they may. Roosevelt agrees. And he says that was the impression that was given to everyone. So what happens? He also stated he couldn't see any policy that would limit Jewish immigration coming out of the mandate. He said he could not give his approval to the 1939 White Paper. And then, based on these convictions, based on these opinions, what did he do? He directed his Secretary of State not to protest or publicly disclose the White Paper's violation of the mandate. According to Roosevelt, mum's the word. Nothing to be said about the White Paper. But the United States had entered into something called the Anglo-American Convention of 1924, and that gave the United States the same rights as members of the League of Nations. Remember, the United States didn't join the League, so it needed separate treaties to get League rights, and it had one here. It had a treaty with Britain that guaranteed it the same position as Bulgaria or Romania or any other nation in the world, and the Jewish residents or occupants of those nations had the same rights under the mandate that they would have had if they would have been League of Nations members. Here are the provisions. They guarantee those rights. It includes the right to make claims against Britain for mandate violations. Here's all the language, and what happens? The international court's not available, of course. We can't sue, but we could have protested in the United States. The United States could have protested the White Paper diplomatically and publicly, but Roosevelt kept his disapproval of the White Paper secret, and he told his Secretary of State, Cordell Hull, and by the way, Cordell Hull says in his memoirs, I agree with Roosevelt. This was a violation of the mandate. But mum's the word. We're not going to do anything about this. We are aware of no legal action that can be taken to protect U.S. property or other rights infringed by the White Paper. In summary, Britain violates the Palestine Mandate, causes the deaths of thousands of Jewish refugees from the Nazis who are trying in vain to take refuge in Palestine. Churchill agrees Britain is acting illegally, does nothing. Roosevelt agrees that Britain is acting illegally, but refuses to protest to protect the interests of American Jews in their investments in Palestine, and they'd invested hundreds of millions of dollars. So, I leave you with two maxims. Abraham Lincoln said, law without enforcement is just good advice. Is that what we were doing, is giving Britain good advice? Or was it supposed to be something more than that? And the second one, this is the motto, by the way, of the University of Pennsylvania. Legus sine moribus vanae, statement by Horace, laws without morals are useless. Even though this was illegal action, and even though two presidents agreed it was illegal action, it was their morality that ultimately controlled this. The laws themselves were useless. Thank you. Break for lunch.